Right. So good morning, good afternoon, good evening from wherever everyone's joining in. We have a pretty interesting discussion lined up for everyone. Of course, as you're aware, the focus is going to be the India-Korea corridor, and we're going to try and focus on the key issues that parties face in cross-border transactions from an international arbitration perspective. I have a great panel for us as well today. So we have James Morrison, who's a partner with the Sydney office of P&K. He's a specialist in international arbitrations, acts as both an arbitrator and counsel, and has extensive experience working with multiple arbitral institutions. He was, in fact, the former counsel with the ICC International Court of Arbitration in Paris and a counsel with the Arbitration Center for International Commercial Arbitration in Sydney. We're very happy to have him here with us. We also have Mino Han, who's a partner with Peter and Kim, and he has vast experience again in various international arbitrations before various institutions, including the ICC. He represents contractors before Korean courts and as well as in KCAP domestic arbitration proceedings. We have Tejas, of course, who's the director with the ICC arbitration in ADR South Asia. He focuses on assisting companies, councils, and investors in understanding how they can resolve commercial disputes by raising awareness about ICC's dispute resolution services. He also advises on arbitration proceedings protocols, primarily, of course, with ICC. I also have my colleague Saman, who's a partner with the Delhi office of Catalan Company. She has more than a decade's experience in the field of dispute resolution, has represented clients on wide variety of claims under Indian arbitration laws before the ICC, the SIAC, LCI, etc. And in fact, also advises on issues relating to enforcement of foreign decrees and awards in India, and as well as bilateral investment treaties entered into with India. And has in fact been involved in some of the largest arbitrations with a cross-border element in India in the recent past. And I'm Ravi Tej. I'm a partner with the dispute resolution team in the Bombay office. I primarily represent clients in civil commercial disputes, both in litigations and arbitrations, with a focus on debt recovery, sharing the disputes, and pre-litigation advising. So that's the panel that we have, and sort of to dive right in as to what is it that we're looking to cover today. We're looking to cover some of the issues that that are faced in international commercial arbitrations with an Indian element, and to sort of focus on some key considerations that we need to sort of focus on while drafting dispute resolution clauses involving Indian and Korean parties, both in situations where substantial assets in India as well as outside India. We'll also look to cover on best ways to sort of secure interim protection, and also, the ever-evolving contours surrounding the enforceability of emergency awards, both in India as well as foreign seated arbitrations. These are things that have been widely discussed lately and become very relevant in that sense. And obviously, I think before we sort of get into the panel discussions, I think it's just important for us to sort of understand why is it that arbitrations are generally the preferred mode of dispute resolution over litigation now. The first, of course, is because it's quicker, it's faster. The process in itself is more flexible. Not all procedural aspects of litigations apply, so parties to some extent get to decide their own procedure. Of course, obviously guided extensively by the rules itself. Courts generally are overloaded with cases, and therefore the tribunal becomes a better way to have cases heard out and decided in a shorter period of time. Obviously, the way the Indian legislation has evolved over time, it's to sort of give the tribunal as much discretion, give party autonomy, primacy, and therefore even a challenge to an arbitral award now is on very limited grounds, and courts tend to not interfere too much with how arbitrations are functioning. Having said that, of course, there are certain things that one needs to keep in mind while choosing arbitrations, because it could at times be a fairly costly affair. Having said that, and I'm sure Tejas can come in on that later as well, that a lot of it is a myth, because people believe that your initial costs itself indicate that overall the process is expensive. But I think what the rules do is it streamlines the process, makes it quicker, and therefore, while cost could be a factor initially, overall net, because it's all done in time-bound, controlled fashion, it doesn't tend to be that expensive. But the other factor that one needs to bear in mind is how many arbitrators are we talking about? Is it a sole arbitrator? Are there 3 arbitrators? Do we need a technical member? Is it technical in nature that you do require an engineer or someone of that sort to sort of be on the case? Or do you prefer the tribunal to be that of judges or practicing advocates, etc.? These are factors that needs to. The other factor, obviously, and we'll discuss more on it as we go, is on the seat of arbitration, because seat sort of becomes the center of the universe as far as the arbitration process is concerned. So we need to sort of keep in mind where the assets are, where's the likely dispute arising. If we're picking the seat outside of India, is that country recognized by India as a reciprocating country under the New York Convention? So these are factors that one needs to bear in mind. And of course, whether a dispute is arbitrable in itself or not, because certain disputes in India are not arbitrable, like shareholder disputes, certain trust disputes, certain financing disputes, etc. So those are things that sort of need to be borne in mind while making that choice of whether to arbitrate or litigate. But obviously, the chips sort of, at least in our view, tend to sort of favor arbitration over litigation. And I'd like to sort of bring in Tejas on this and give some thoughts, and then happy to hear the other panelists also with some thoughts around this.
Yeah, thank you, Ravitej. Good afternoon, good evening, everyone. So very interesting question to start with a very basic question as well, but there is just so much that is going on here, right? Ravitej, you mentioned that arbitration is flexible, is transparent, is neutral, and that is something which are the top 3 conditions for parties wanting to go for arbitration. Another interesting perspective and another interesting stat here is that while it is cross-border and it is international, what we see at the ICC, for example, more than 20% of the cases that we had, the parties were actually domestic parties. So it is something which is also chosen by domestic parties. And I think the reason for that is all that you just mentioned. There is flexibility. Parties are able to choose their place of hearing, when they want to have their hearing, how they want to go about the submissions. They're able to constitute their tribunal. So I think all of that just falls in place with what companies, what businesses, what lawyers want. Happy to have everyone else's perspective before I chime in on the other aspects.
Ravitej, if I may, when we speak with our clients, I guess 2 points come to mind. I think we need to place a greater emphasis on the enforceability point. If you choose international arbitration, you have at your disposal 169 different jurisdictions which are party to the New York Convention. This means an arbitral award rendered in a place of arbitration that is party to the New York Convention is enforceable as a judgment of a foreign court. So that's a really attractive thing, because the existence of cross-border enforcement of judicial awards that is anywhere near comparable to international arbitration. The other short point I'd like to make, which is rather a non-legal one, is the kind of psychological element that follows from all the points you're making about flexibility. By choosing arbitration, parties are able to exercise autonomy, agency. They're invested in the process. They have control over the process in a way that they just don't get in a state court. And our clients, at least, they're really attracted to that, because if you are invested in the process, you have greater confidence in it and its outcome. And that's the reason why, even before getting to things such as the New York Convention, I think the statistics tell us that up to 90% of arbitral awards are voluntarily complied with. So again, I think this psychological factor of arbitration is often undersold.
Right.
Yeah. Then there's the confidentiality aspect as well. Again, something which is very important to a lot of people. So that is also, and that differs, of course, from rules to rules and how you go about confidentiality. But again, a very important factor to an arbitration.
Right. James, it's interesting you mentioned flexibility and autonomy as some of the key facets of arbitration. But do you see that differ in an institutional arbitration scenario and an ad hoc arbitration scenario? I mean, what do you like, the key differences that you see between institutional arbitration and ad hoc arbitrations? And is that a factor while you all are drawing up contracts or advising clients as to which to pick over the other?
Sure. Maybe we can just go through a bit some of the key differences between institutional and ad hoc arbitration, because that will assist, I think, in explaining the different considerations and driving factors about why parties exercise their autonomy one way or the other. Because in an institutional arbitration, you have a specialized organization, institution, secretariat, court, like the ICC Court of Arbitration, which supports the arbitral process. Each institution, of course, has its own set of rules, and they're going to provide you with a default framework for the way the arbitration will basically roll out. Some institutions provide what you might call a broader full service type of administration, and arguably the ICC kind of falls in that end of the spectrum. But other institutions provide what we might call a more light touch administration. And I'd say that some institutions like the Australian Centre for International Commercial Arbitration fall into that category. And, it's choose your own adventure. What kind of arbitration do you want? And ideally, you choose whether you want an institutional arbitration or an ad hoc arbitration in advance of the dispute arising. You do this in your arbitration clause. But where there's no institution, it's what you've called an ad hoc arbitration. And here you have a more pure expression of party autonomy, if I can put it that way, because here the parties are by themselves. They have to agree on all aspects of the administration of the arbitration, and that's fine, but you just have to acknowledge and be aware that actually places a greater burden on the parties, because they themselves have to agree and administer everything. And if they don't agree on it, then it falls for the tribunal to determine. So it puts a greater burden on the tribunal. So if you don't have default procedural rules like an institution like the ICC, you end up having the tribunal to determine all sorts of things which would ordinarily be assisted by the institution. The place of arbitration, the basic procedural rules, the management of costs, and that's a really important and burdensome thing that the ICC and other institutions assist and support parties and tribunals in doing. So they're kind of some of the basic differences, which I think can help craft and support parties' decisions about whether to go one way or the other. It's just about how much work do the parties want to do.
James, in fact, from an Indian perspective, what you've said is absolutely true. Ad hoc arbitrations in India have been seen to be not as efficient as institutional arbitrations. And very often, if the respondent just wants to delay proceedings, they could raise a dispute on any and everything, and you'll be running to court. Whereas in institutional arbitration, a lot of those aspects are taken care of. And surprisingly, at least in the recent 5-6 years, I've seen a lot of, so typically, if we were choosing an institutional arbitration, at least traditionally it would be if it had an international or a cross-border element. So you would have an Indian party and a foreign party, and then they would opt for a institutional arbitration mechanism. But increasingly, we are seeing even domestic parties where two Indian parties just want to opt for an institutional arbitration simply because they know that the process is more efficient. It's just quicker and without judicial intervention.
Saban, you've made a great point, and I think this is one of the key reasons people choose institutional arbitration over ad hoc arbitration, because what you're doing is you're opting in to what is already a pre-established, it's stable and well-tested framework of procedural rules. And in the case of the ICC, you've got a set of rules which have been established, revised, improved in line with international best practice since 1922. So you have 100 years of institutional experience in supporting you in an arbitration. So what you're doing is you're opting into a system whereby you have a circuit breaker. If you have one party that's trying to obstruct the procedure, you have an institution which is ready to step in and break the roadblock, because it has administrative powers conferred by the power of contract to move the process forward. And it does so in a number of ways. For example, the institution itself notifies the request for arbitration. This assists in giving kind of legitimacy to the commencement of the procedure. The institution can appoint arbitrators if a party fails to do so. It can also remove them if a party seeks to appoint a non-independent arbitrator. And again, coming back to the management of costs, I mean, this is an understated thing. I've been in ad hoc arbitrations, and this actually ends up being quite a burden on the party and their counsel to deal directly with the tribunal to manage costs. And the ICC system provides an added level of certainty, because costs are calculated in the case of the arbitrator's costs by reference to the amount in dispute. But there are other ways the institution can assist, because it can determine prima facie that there is an ICC arbitration clause, and again, this provides legitimacy to the process. And there's also the award scrutiny process, which we can come back to. But the point I want to emphasize here is parties are buying into and they're investing in a safety net, not only to enhance efficiency, but to mitigate against the likelihood of roadblocks by the kind of behavior that you've just pointed to.
Yeah.
Tejas, you want to come in on this? I mean, I'm sure you'll get a lot of questions on why do we pick an institutionally run arbitration over ad hoc, and what someone just said becomes relevant as well, right? Because earlier we saw this happen only in cross-border disputes, but now we're seeing that sort of trend move towards even purely domestic arbitration.
Yeah, absolutely. Happy to chip in, and thank you, James, for I think just setting the stage. I think James has covered a lot of what I wanted to say. But these are questions that we often get in terms of like, why an institution, right? And let us go back to what an institution does. While the ICC is called the International Court of Arbitration, it is not a court per se. It is an arbitral institution that administers disputes based on its rules and is aided by the secretariat, the case management teams that the ICC has in Paris, New York, Sao Paulo, Abu Dhabi, Singapore, Hong Kong. Now, when parties are contracting with choosing an arbitral institution, they're looking at the service that an institution will provide, because in the end, the institution is a service provider. And that is where the institution also has to provide accountability and transparency. And another very important factor is that, okay, I will subscribe to the ICC rules and I would want to, have my arbitration administered by the ICC rules. But what is the service? Yes, there is the service on the appointment, the arbitration being on time, there's supervision on the arbitration, etc. Very important factor, which is something that deals with costs, and costs are very important to clients and lawyers as well. Now, what happens if your tribunal is delayed in an arbitration? In an ad hoc arbitration, you probably can't do much, right? You will probably follow up. But if it's an institutional arbitration, under the ICC rules, the ICC will sanction the arbitrators, sanction to say that will reduce the fees of the arbitrators and give it back to the parties. Now, everyone's probably thinking that this is for the arbitral tribunal, and this is all in case of an unjustified delay. What happens when the institution itself is delayed? What happens when the ICC forgets to transmit the file, or the tribunal is not constituted? The rules in the note also provide that the ICC will reduce its own administrative fees. And again, this is something that comes back to the parties. So this goes to the question of accountability and transparency, because the parties are paying the institution for a service and the institution has to be transparent, right? In terms of cost, a very interesting study which was covered in the ICC Commission report, every $100 that is spent in an arbitration, hypothetically, only 2% is actually the institution fees, because the institution fees is actually capped. So this whole question about, do I choose this institution? I've heard that this institution is expensive and that one is cheaper. Yes, there could be a scale, and there is a scale of all these institutions, but you're essentially talking about that 2%. So that is not the major cost. The major costs are with the tribunal, with the legal fees, the expert fees, etc. So again, things to keep in mind when choosing the institution.
Right. No, that's interesting. And as I said, right, a lot of it is just a mindset change, which thankfully, as I said, is also now sort of changing with parties picking that as their default setting as well. But I think now to sort of move to the more the starting point of all of this, right, is the dispute resolution clause. And as disputes lawyers, we often joke about how 30% of our work comes out of a badly drafted dispute resolution clause. And while ICC and you look at the rules, and then the suggested model clause is as concise as it is, I've never seen it as concise in any agreement till date. So Saman, if you could just sort of come and give some insights on what are the key considerations to be kept in mind while drafting an arbitration clause. What are the key ingredients? What should be kept in? What should be kept out? And and then I'll come to Mino and try and understand what's his experience in Korea on the same thing.
Sure, Ravi Tej, you're absolutely right. A lot of our bread and butter, unfortunately, is before you even get to arbitration, because there's a lot of dispute on, what the parties intended with the arbitration clause, and very often it's corporate lawyers who may or may not have consulted litigation lawyers. So I think the key over here really is to draft your arbitration clause in a manner which is as precise and certain as possible, and not leave it in terms of a vague and ambiguous clause. So, I mean, just to give an example, if there's a pre-arbitration clause, there should be it should be a time-bound mechanism. It should have mechanics on how a pre-dispute notice will go, how much time should the parties amicably discuss the matter. There should be a clear stipulation as to the number of arbitrators that would adjudicate the dispute. If it's an institutional arbitration, again, a clear stipulation as to which institution will be administering the dispute. Things like venue of arbitration and, of course, seat of arbitration, which we briefly touched upon. And seat in particular, I think, is of great significance and something that the parties should think through, apart from the fact that, particularly in the Indian context, the award should be made in a country which is a reciprocating territory, so that it's directly enforceable. That's one of the factors that you should keep in mind when you're designating the seat. Other than that, there are various aspects. For example, the validity of the arbitration clause, things like cost of arbitration, interest, all of that can depend extensively on what is the seat of arbitration. And eventually, once you have an arbitration award, the enforcement will also be before the seat court. So, keeping in mind all of these factors, it's very important to choose a jurisdiction which is very arbitration friendly, which has an established regulatory and legislative framework which supports arbitration. So you have minimal judicial interference as you go along conducting your arbitration, and the expectation that the award is finally enforced, that kind of holds true. So those are some of the factors that I would say one should keep in mind when you're drafting an arbitration clause. Just be as certain and precise, and don't leave things vague, and so that they don't end up in a dispute later on.
Right. So Mino, and what's the experience been like in Korea on this? Because as I said, for us, it's a third of the work that we're doing because of the way it's drafted. But what's the experience been in Korea, and what are the sort of advice that you all are giving your clients while drafting these clauses, or your corporate colleagues?
Thank you, Ravitesh. Before I move on to the Korean practice and my experience, just quickly responding to Saman's point as to arbitration-friendly jurisdiction. I think there are two schools. One is where a court would never set aside an arbitral award, and that country says we are arbitration-friendly. There are other countries who say we do set aside arbitral awards and safeguard the quality of arbitration, and how we are more arbitration-friendly. So I haven't yet decided which jurisdiction is more arbitration friendly, but it occurred to me, just wanted to flag that. Moving to Korea, I think it coincides or correlates with the Korean business culture a little bit. Here, the culture, I wouldn't say it applies to every industry, every case, every party, but speaking in general, either the Korean parties don't like to initiate an arbitration and try to settle the case amicably, or if they do, they want to fight and get the award and the outcome, and they fight until the end to go to the hearing and see the award from the tribunal. So it's either or, meaning a multi-tiered dispute resolution clause often doesn't work. Either you settle the case in any case, or you are in a fight mode already, such that these multi-tiered are just cumbersome steps for a party who's really ready to fight. Having said that, in construction contracts, especially FIDIC-based contracts, which are followed by Korean contractors a lot, the multi-tiered dispute resolution clause with an ICC arbitration clause at the end is pretty standard. And our experience has been that a sort of mandatory mediation or mandatory amicable dispute resolution step didn't really help for the reasons I just mentioned, the Korean business culture. But since the Singapore Convention has come into place, I'm curious whether that sort of practice or culture might shift and change. But I'll stop here.
Right.
Yeah. If I could also
Yeah,
step
go
in.
ahead.
Yeah, one thing that we always say is that for arbitration clauses, for dispute resolution clauses, less is more. Please stick to what the institution is providing. If you're going for an institution, all institutions have a standard dispute standard clause. Stick to that. Just specify the seat governing law and what the institution is asking you to specify, or just call the institution. Institutions would be very happy to advise on this as well. For law firms, please consult with the dispute resolution team. Don't be very creative. The corporate team tends to just be very creative with the clauses. You mentioned FIDIC, but something that we often see is that we also come across clauses that are standard FIDIC templates, but they've also been modified, right? So maybe someone has something going on in their head and they're doing that, but please don't do that. This just creates a lot of trouble.
Right. No, and I'm glad you say that, because in fact I was coming to that itself, is that I think let the people hear it from the horse's mouth that look, keep it concise. A 3-line model clause is sufficient for everything to get covered in it. The rules provide for everything. The laws of the country provide for the rest of it. So you don't need to really jumble it in. Yeah, James, sorry.
I don't disagree with that, and I don't disagree necessarily with the less is more approach. Again, I'm a big fan of party autonomy. So if parties want more, they can have more. I think the message that is following from everyone's comments here is basically you need to really think about it and get careful advice. I think a lot of the kind of bad practices that have been touched upon, sometimes they just follow from the practice of lawyers in the front end, basically going to the corporate department and copy pasting arbitration clauses used in other contracts, and then without kind of careful consideration, pasting them into another contract. And that's just a practice that we as lawyers need to educate ourselves about, and we need to look after our clients to avoid those kind of lazy practices. So less is more, but more can be more too.
Right.
Yeah.
And then I think the most complex issue in these clauses is the issue of seat. And a lot of litigation that we've seen, not just now, but since the law since the Arbitration Act of 96 has come into India, in fact, even before that, is on the issue of seat, is that, seat versus venue versus place. And there's just a lot of confusion around it. So someone if you could just run us through the judicial proceedings, and that have sort of come in over time to try and resolve the issue of the confusion regarding the seat of arbitration.
Sure. No, you're absolutely right, Ravitej. I think if you look up Indian judgments, at least 40% of them would be debating whether a particular country is the seat or is it the venue, or so a lot of judicial precedents on that. But I think broadly, at least now, it's fairly settled. Indian courts do recognize the distinction between venue and seat. So venue is very simply is just a geographical convenient location for parties to meet, convene, where hearings can take place. It's just a matter of, as I said, geographical convenience. And seat, as we just discussed, has far more serious connotations, because once you designate a particular location as a seat, it'll have a bearing on various aspects like validity of your clause, eventual enforcement or a challenge before the seat court, and so on and so forth. And broadly, that's the kind of distinction that courts have maintained. There have been, I think the confusion is created when the arbitration clause is not very clear. It's simply, if, for example, just to cite some of the recent Indian precedents, there was a recent case where the arbitration clause simply said that the place of arbitration is Hong Kong. And when the Supreme Court was examining it, what it concluded was that merely saying place of arbitration is Hong Kong would not mean that it's the seat of arbitration, and it has to be something more. It has to be something more precise. So, for instance, the court said that if the clause had said that the Hong Kong will be the place where the arbitration would be administered, that is something that would give it the flavor of a seat. But then on the other hand, you also have a slight judgments which are slightly at variance, where there's another judgment of BJ Soma, which is also a Supreme Court judgment, where they said that once the clause refers to the place of arbitration, then the intention is likely that that would also be the seat of arbitration. So it really sort of depends overall on surrounding circumstances, and obviously the best way to avoid the whole confusion is to just very clearly state what is a venue of arbitration and what is a seat of arbitration. And it may well be that the venue of arbitration and the seat of arbitration are really the same place. So it's just always better to be very clear on which place you would like to designate as the seat of arbitration as opposed to the venue of arbitration.
Ravitesh, can I jump in there?
Yes, absolutely.
One thing that the pandemic has done is that it's developed or changed or created a new concept of venue, because now we have the virtual venue. People have been forced to embrace the virtual hearing. So all these things that Saman has touched upon about the geographical concept of hearing or the place of meeting has really taken on a different meaning. And courts have also been grappling with that because they've had to decide whether a tribunal can go ahead and hold a hearing virtually without any physical place against the objection of one of the parties. I'm not sure, to my knowledge, there's no precedent yet in India about this question, and I'd be interested from the Indian lawyers on the call whether there is, but there are other jurisdictions which have grappled with this question, and venue has been confirmed to be legitimate in the virtual world. The courts have said tribunals can go ahead and hold, in appropriate circumstances, provided a full opportunity is provided to be heard, hold hearings in the virtual space. So I'd be interested to hear from my Indian friends.
James, that's actually a very interesting point. Very recently, it was an interim measures hearing, and the arbitration was seated in Singapore, and the arbitrators were all in London. And what we had said was, we had insisted on a physical hearing, and we had said, let's have it in London because it's convenient. The arbitrators are all there. We can fly over. The other side said, look, the seat is Singapore, and we would rather that any hearings are conducted in Singapore. And there's a lot of back and forth on that. And eventually we suggested, okay, let's have it hybrid. So if you're not able to travel to London, let us travel to London, and perhaps you can attend virtually in Singapore. And eventually the tribunal said that this hybrid sort of a hearing is slightly unfair to the party who is not physically present. And eventually we attended virtually from India, they attended virtually from Singapore, but the tribunal convened physically in London. So as you're saying, it's all very dynamic, and this is all changing now with COVID, and we're all sort of getting used to this new order. So venue is, as you said, it's all virtual. It may not necessarily be a physical place at all.
Right. Tejas, do you see a lot of these requests?
Yes, so a lot of these requests as well, and something that we also see is to understand what is the party's intent. So, whether they're talking about having the venue of hearing, I think that is something which is not required and which can be discussed later when the arbitral tribunal is constituted. Another issue is that a lot of times parties link the institutions with the seat. So, for example, there would be two Indian parties and they'll subscribe to an ICC arbitration and they'll have the seat of arbitration in Paris for some reason. That is not required. So I think clarity there that institutions are not linked to the seats is also very important. You can have an ICC arbitration in India, you can have it in Korea, you can also have it in London, Paris, New York. So I think that is also something that we normally see. but a lot of these virtual hearing requests. One issue with virtual hearings, since we touched upon that topic, is to manage times. When we have these parties across borders, London, Australia, and India, for example, or New York, then it's a problem just getting that time right. So I think that is also a consideration.
Right. And James, just to add to what you said, we've not seen too much jurisprudence around seat in the virtual world. So in that sense, in India, at least, seat is still considered in the traditional sense the seat of arbitration per se. So while parties can do their hearings virtually wherever they are, but the seat as specified in the agreement remains the seat irrespective of where we sort of convening the arbitrations in hybrid or virtual or physical form. So I think yeah. With that, let's move on to the second section of what we wanted to discuss. And again, in light of what Mino was saying, right, that it seems to be that the business style in Korea seems to be to try and settle disputes. In fact, even in the post-pandemic world in India, parties are extremely mindful of costs and how much they want to sort of invest in litigations. So one tool that becomes extremely effective in getting people to the table, getting leverage on the table, and sort of figuring how to do it is an effective interim order. So keeping that in mind, someone just if you could just sort of talk about what the enforceability of an interim order / award passed in a foreign seated arbitration in India.
Yes, so that's a little unfortunate, Ravitesh, because the Indian Arbitration Act actually does not have a provision which provides for enforceability of interim orders which are passed by foreign seated tribunals. And when it comes to interim awards, while the definition clause of the Arbitration Act defines awards to include an interim award, and of course awards are enforceable, but even an interim award is construed as something which finally or conclusively determines some of the issues that are there in arbitration. So if the directives that are given by way of the interim award is something that is intended to operate only till the pendency of the arbitration proceeding, again it qualifies as an interim order, and then that is not directly enforceable under the act. However, I think the thing to note over here is that pursuant to amendments that were brought in 2015 after the Law Commission recommended highly that interim measures should be made available to in foreign seated arbitrations. What has now happened is that there is a provision under Part 1 of the Act which typically applied to Indian seated arbitrations, which is the interim measures provision, and that interim measures provision is now applicable even to foreign seated arbitrations. So essentially it means that you can directly approach Indian courts for grant of interim measures, and the orders passed, and this is particularly the case when it comes to situations where the assets are located in India, or you want an urgent direction against an Indian party. So it's just far more efficient to file directly an interim measures application before the Indian court under Section 9 and get an order, particularly if you're in very urgent circumstances, rather than have a foreign seated arbitration, rather than have a foreign tribunal pass an order which is not directly enforceable. And in fact, there's a judgment of the Delhi High Court, which is very interesting. It's the Raffles judgment. And that judgment recognized that the Indian Arbitration Act does not have a provision for direct enforceability of orders that are passed by foreign seated tribunals. And it said that the remedy really is, it's not like the party is left remediless. The remedy is that you approach the Indian courts directly. Interestingly, what the court also said was that if you had if you did have an order from a foreign seated tribunal, Section 9 wouldn't be really a mechanism to enforce the order that has been passed by the foreign seated tribunal. But in fact, the court in Section 9, the Indian court in Section 9, would independently apply its mind to the merits of the interim measures application, and it would be a sort of a fresh adjudication where it would independently see whether those interim measures need to be granted or not. So really the workaround is to sort of approach Indian courts directly when you are wanting relief in respect of Indian assets or against Indian parties.
Right. So are there also any specific conditions under which an interim order can be sought? For instance, only if assets are in India, or there's no such bar as such?
there's no legal bar really, but of course, from our experience, we've seen that 9 times out of 10, if a party is approaching the Indian courts, it'll be because the assets are located in India. You want protective orders with respect to the assets, or you want to go against an Indian party. You want them to secure a particular amount in question, or maybe give a bank guarantee while the dispute is ongoing. And the concern really is that while the arbitration is pending, the assets shouldn't be frittered away, so that eventually you're left with a paper award. So it's really towards that end that the Indian courts in a Section 9 will grant relief.
Right. And what's the experience? How does it work in Korea?
I would like to distinguish interim orders ordered by the tribunal with emergency reliefs or emergency orders. There is a specific provision in the Korean Arbitration Act that was amended in 2016 on interim orders issued by a tribunal, and it says they are indeed recognizable and enforceable. Having said that, I haven't seen so many cases in practice where interim orders have been applied to the Korean court for enforcement, leave alone foreign interim orders. So there's not much court precedents clustered on that, but have to see. Whereas for enforcement, for emergency orders, there is no such provision, and hence they are considered non-enforceable in Korea. As Saman mentioned, the Korean court has sort of also similar preliminary injunction or provisional attachment orders available, which we often use, or we often advise the parties to use, and is granted rather easily. The threshold is relatively low in comparison to other freezing orders, as you know, in some other common law jurisdictions. So court assistance is sought a lot, and yes, that sort of supplements the system for the time being.
Right. Okay. Saman, so then if that being the case, then what's the best manner, the net to sort of conclude? I know you've sort of covered it already, but if you were to sort of give one quick hack, what's the best way for a party to sort of try and get an interim order in a foreign seated arbitration enforced or sort of enforced in India in that sense?
I think the best way really is to approach the Indian court directly, because sometimes parties are compliant and they'll just comply with an interim order that is passed by a foreign tribunal. But there are instances when they simply don't, and then you're left in a situation where you have an interim order which you can't enforce directly. So the best way is really to get an order from the Indian court, because the party is situated in India or the asset will be located in India. It's something that will be immediately enforceable, and you can hold a party in contempt if they still go ahead and they don't follow the Indian court order. So it's just a more sort of a robust remedy. And I'll just clarify, since Mino mentioned emergency orders that are passed by emergency tribunals. They really have the same status as interim orders that are passed by foreign seated tribunals. So while when it comes to domestic or India seated arbitrations, there's a very recent judgment, Amazon versus Future, where it clarified that if it's an Indian seated arbitration where an emergency arbitrator has passed an interim order, that would have the same effect as an interim order, and it would be enforceable as an order of the court. The facts in the Amazon case unfortunately dealt with an Indian seated arbitration, so the roadblock when it comes to enforcing a foreign seated interim order remains. So even an order that is passed by an emergency arbitrator in a foreign seated arbitration, it'll remain unenforceable in our view.
So Tejas, do you see this as a concern where parties, especially from India, come in and say that, look, why do we sort of rely on the emergency process when it's far easier for me to just approach an Indian court? I mean, what's been your experience, vis-a-vis, in connection with emergency, etc.?
Yeah, so This is, of course, yes, the challenge, and we do have requests like those where you have court orders, etc., and you have to deal with parties that are not responding. But emergency arbitration is something which is very clear in the rules. That is something which is provided under the articles where parties seeking short-term relief can actually file for an emergency arbitration, where you have the emergency order within 10 days. And you have to follow it up with the request for arbitration under the ICC after 15 days, within 15 days. But to answer your question, yes, we do have a lot of those, and we do face challenges with that, and that's why we need Indian qualified lawyers in the Secretariat. James wanted to say something. I think he wanted to chip in before.
Yes, I don't wish to detract from the very good sense that Saman has made about the sensibility of approaching Indian courts for interim relief. I do, though, want to emphasize that actually, even if the order from either an emergency arbitrator or the tribunal itself is unenforceable in a state court, they still carry great weight in an arbitration.
Yeah.
And I think it's quite interesting, Imino's comment before about not seeing really any cases about enforcing arbitral tribunal ordered interim measures in Korean courts is interesting, because in my experience, there are more and more requests for interim measures and emergency arbitrator orders being made in arbitration. So there is this disconnect, but I think it suggests that parties see great value in obtaining these orders from emergency arbitrators and tribunals because of the inferential power that can be drawn in the event that a party fails to comply with an emergency order or a tribunal issued order. And so that's why I think parties are more and more seeking to make use of this tool, because it's not without value, even if it is technically unenforceable in a state court. So I think we shouldn't lose sight of that fact. It's still a very powerful tool in an arbitration.
Right.
No, absolutely, James. Sorry, go ahead.
No, go ahead. I'll come in.
No, I was saying that you're absolutely right. In fact, 8 times out of 10 parties will comply with the order that has been passed by the emergency arbitrator. And I think in my experience also, once you have an order from the emergency arbitrator, the Indian courts will have to have very, very, very strong reasons to sort of disagree with the approach that has been taken by the emergency arbitrator. So you're absolutely right. It does have a great persuasive value, but strictly on a very legally, technically, they're not enforceable. So that could be a hurdle. And maybe you can also assess your counterparty. If it's, a rogue counterparty, which is very unlikely to really follow anything, then, maybe the best way out is to approach the Indian court.
We had a recent experience in an emergency arbitration where we acted as counsel, and we successfully obtained an emergency order for the party. And it had great power because it showed the other side that their case was actually quite weak. And what happened was, following the emergency arbitrator proceedings, the whole thing settled favorably for our client. So if you're able to get these early orders, they actually can have great persuasive force.
Right. But Meena, has this been tested before Korean courts? Like someone mentioned, in India, we've had it being tested in an India-seated arbitration scenario, but not in a foreign-seated arbitration scenario. But has that been tested before the Korean courts on emergency awards, their enforceability, etc., or just as they said, it's just persuasive value?
I would be careful to say yes or no, but at least not to my knowledge has it been tested at the Korean courts whether or not an emergency order is enforceable. Just circling back to what are the hacks in Korea, and I agree with Jim and Saman that in an emergency order is of value. Having said that, it can't prevent asset dissipation, and for that, as I briefly mentioned, provisional attachment order, which is sort of a freezing order issued by the court, is relatively easily obtainable at the Korean court, which is what we advise clients quite frequently to pursue. You need to put in a certain amount of deposit, either in cash or by securities, but that's not too complicated, and that's sort of a secret hack. It's not a secret, but it's a hack that you can use when the asset is based in Korea.
Right. So, now sort of to move on to the larger award scenario. Is the experience different when it comes to a final award versus interim and emergency award? I'd say the short answer is yes. But generally speaking, someone what's the coming to a final award pass in a foreign seated arbitration, what's the best way to enforce it in India?
So
And I'm talking
a
about
foreign Sure. So a foreign award is actually enforceable under Part 2 of the Indian Arbitration Act, and fortunately, we've seen both legislative changes and a lot of a lot of pro-arbitration friendly judgments. So there are actually very limited grounds of challenging a foreign award today, and at least in my experience, I haven't seen any major foreign award getting upset in the last 3-4 years. So there's reasonable certainty as regards its enforcement. I think one of the primary concerns that parties have when they're coming to enforce their awards in India is how do we secure the arbitral sum in question, because under the Indian Arbitration Act, once you file the execution petition, the other side does have a right to raise objections, albeit on limited grounds, and that process can take a while. So how do you secure the arbitral sum in question? And there, I think there are a number of things that the courts can do. They can either direct a deposit of the arbitral amount, or they can secure the arbitral amount by way of a bank guarantee or a corporate guarantee. They can also maybe pass orders restraining a party from creating third-party rights over unencumbered assets. Under the Code of Civil Procedure, you can have orders, garnishee orders, where debtor of the award holder, of the award debtor, is made to pay the sum that is due directly towards the satisfaction of the arbitral sum. So there are a number of ways in which you can secure the arbitral amount and make sure that at the conclusion of the arbitration, at the conclusion of the enforcement proceedings, you will get money in your account. And I think this, as you said, Ravitesh, the standards when it comes to enforcement are not as high as when you're asking for these sort of reliefs at at a stage when the arbitration has not yet begun or the arbitration proceedings are pending, because of course you're coming back, you're coming at the back of an award which is in your favor. So it's relatively easier to get that kind of relief from the executing court in India.
Right. And Mino, in terms of the reverse, so enforcement of foreign seated arbitrations in arbitral awards in Korea, are courts generally less interfering, or are they, do they sort of look at it again with a magnifying lens? Are merits gone into, etc.? Because as someone said, in India, it's largely, we see awards getting enforced and not the other way around. How's it been in Korea?
Korean courts are very pro enforcement, and I understand that there has been no foreign arbitral award ever in Korea that has been set aside. I'm happy to be corrected if anyone tells me otherwise. There is sort of a tendency within the Korean court that we need to be international and we need to be arbitration friendly in that sense. So enforcement is very widely accepted. Going back a step, and perhaps also a question to Saman concerning Indian business culture, was curious what the extent of voluntary compliance would be. We talk a lot about enforcement at the court, but before we get there, whether companies tend to comply to payment demands after an award has been issued voluntarily. In Korea, again, difficult to say this is the trend, this is the tendency, but we also see a number of cases where voluntary payment is being made. If not, we sometimes advise the clients, instead of going to the court, just simply again apply for a provisional attachment order, sort of to push the other side and make the other side a little bit more difficult, and then they comply. But was curious about sort of your experience with voluntary compliance.
I think Ravitesh will agree with me. I've not seen a lot of voluntary compliance, at least when it comes to an award against Indian parties, and you will end up in courts, and you will likely go through the rigmarole of enforcement objections and then having an order in your favor. So unless Ravi Tej has seen anything different, I haven't seen a lot of voluntary compliance.
I don't think I don't think I've seen anything different. In fact, I've never seen that. In a foreign seated or even in a domestic arbitration, I think voluntary compliance is something that's just not around. Which is also why, at least from a domestic context, the act sort of had to be amended, where a challenge to an arbitral award, for you to get a stay on its execution or enforcement, you need to sort of compulsorily deposit part of the awarded amount. That was, that's just part of the reason why. Part of the reason why the amendment came in was because parties would, of course, not voluntarily compliant, and which is also something that is a bit of a concern. Also, that while the arbitration process runs through fairly quickly, it eventually gets stuck in court somewhere. But it helps here now that with the law sort of changing to allow for deposit and parties are not out of pocket for too long. So I think that helps.
Interesting, because in Korea, again, can't speak for every company, but broadly speaking, once you get an award, the post-award interest burden is sort of significant, such that it's difficult for someone to say, let's just take your time and go for whatever enforcement, rejection, or set aside or so, knowing that the chances are slight, and you have that extra post-award interest burden. But interesting to hear that from you.
Yeah, no, I think you're right. Things are changing. In India, post-award interest is 2% above what has been awarded. So, I think at least till some time back, it wasn't really a deterrent, because arbitration proceedings would drag on forever, and then who knows where you would be 5 years down the line. But I think things are changing now, and enforcement getting quicker. And once you are depositing the full arbitral amount, that's sort of half the game is over then and there. So I think attitudes are changing, but we're still not quite there as where Korea is.
Right. If I could just chip in, I think because we're talking about enforcement, and James had touched upon this, which is the scrutiny process, because this is where this process comes in important, right? Because if you're going to the court with your award and you want that award to be enforced, the court is essentially looking at a lot of things, and you don't want anything wrong in the award, right? That is where I think institutions also play an important role. The ICC, for example, it is an absolutely amazing process. I've seen it multiple times. James has as well. He's acted on it. It's a 3-level scrutiny process where you're surprised as to how many times arbitrators will also miss out on certain important things. And what that does is that it will eventually pose a challenge when you go for that final enforcement. Something as simple as interest being awarded. How is that interest calculated? Whether this was simple interest or compounded. How did you jump to the number of 12%? Whether you have sufficient reason to award with this. Proper parties being named. All of this is actually picked up in the scrutiny process, and institutions do scrutiny, but the ICC does it differently because there are court members, which are actually independent practitioners based out of jurisdictions that will also look at the award, subject to, of course, not being conflicted, and make sure that it's as per the law, governing law of the country, it's not against the public policy. So it's actually peer-to-peer review. And this is after the Secretariat, the court has actually reviewed it as well. So I think, again, a very important factor, because enforcement is what you want in the end. That's why you're getting into arbitration.
And if I can just add to what Tejas has very eloquently explained, I come back to the concept of institutional arbitration as a safety net that you invest in by including it in your arbitration clause. And I think the ICC scrutiny process is one such safety net. Parties and clients should rest assured that most awards that come before the ICC court in draft form are very good already. Parties usually appoint very good arbitrators. If the institution appoints an arbitrator, she or he is very good. But as Tejas says, sometimes arbitral tribunals miss things. Sometimes arbitral tribunals make mistakes, be it small or large. I mean, I just can think of one example in a case where I was involved in the scrutiny process, and it occurred in the review of the award that the sole arbitrator had refused to hold a hearing against the objection of one of the parties. And as you would know, if you're familiar with the ICC rules, or basically any institutional rules, if one party requests a hearing, the tribunal has to hold a hearing. It's a requirement of the rules, and so we were able to pick up that error in the review process and bring it to the tribunal's attention, and the court instructed him to go back to the parties and hold a hearing, because that award would be utterly unenforceable in any New York Convention jurisdiction. So you can see the value of the safety net that the institutional rules and the scrutiny process can provide in those kind of examples.
Yeah. And just to put these facts into numbers, because they're again very interesting, last year the ICC had 630 awards which were notified. Of those 630, 621 awards actually had comments from the court for the tribunal. Only 9 awards were notified without any comments by the ICC court, and there were 69 awards which were actually not approved. They were sent back. So I mean, this is a process that actually works, and this is important. Yeah.
In fact, it's interesting you say that also, because what we've started seeing now is that when we go to court in a challenge, and the first question that the court asks is, can we see the award? And it's an ICC award passed by, like obviously people usually, well-known arbitrators. The presumption is already in favor of the award, and that presumption sort of flows through. While obviously I understand, from a lawyer's perspective, there should be no biases, etc. in court. But I don't think this is a false bias or a negative bias, but I think it's just good that it sort of it serves the purpose for which parties are picking that institution, right? And it's always an agreement. It's not that one party is forcing the other to pick ICC to do the arbitration. So I think that stamp in that sense helps. Right.
It
I
does.
Think sorry.
I'm sorry.
No, go ahead, please.
I just wanted to confirm what you're saying by reference to case law. I believe there's English case law where, in setting aside proceedings before the High Court, in rejecting the challenge, the court referred to the ICC scrutiny process as but one of the elements, which gave the court confidence that there could have been no denial of natural justice in not setting aside the award. So, this isn't just lip service we're paying to, the value of this process. It's recognised judicially as being a relevant element in the overall fairness of an institutional arbitration.
That's interesting. I wasn't aware of that. I didn't see that smile on Tejas's face when he hears that.
I made a mental note that I'm going to send him an email and ask for that.
Right. So now to move to the last bit, and while it's slightly disconnected to everything else, but it becomes extremely relevant now, especially because we've spoken so much about costs and time, etc. And that's on third-party funding. So first, Saman and then Mino on how receptive is A, India, and B, Korea been to third-party funding?
So when it comes to India, there's no express law permitting third-party funding, but at the same time, there is no prohibition on third-party funding either. And at least the recent trend is, accompanied by a high-level committee report, which was talking about institutionalization of arbitration, that actually recommended third-party funding, given that it is increasingly getting adopted in all evolved arbitral-friendly jurisdictions like you have Singapore and Hong Kong, so on and so forth. And this report was in 2017, and that was followed by a judgment, Bar Council of India versus A.K. Balaji, which did say that there is no prohibition on third-party funding in India. I think the only caveat is that the lawyer shouldn't be funding the litigation for the client. So that's really the caveat in India, and that is where you sort of draw the line. But otherwise, third-party funding in India, it is in its nascent stage, and the consensus is that there is no prohibition on third-party funding in India.
Right. Mino?
Same in Korea. There is no express prohibition on third-party funding, nor is there any express sort of granting provision positively under Korean law. Having said that, I think I would distinguish litigation funding from arbitration funding. there's a greater chance that litigation funding is considered not legal in Korea, because the regulations on court litigation in Korea and the Korean lawyers qualified to participate in litigations is slightly higher. In arbitration, I think it's gray area, but I think there is a greater chance that it's deemed allowable. We've seen cases, a number of cases, where we had, for instance, US companies as counterparty disclosing that they were being funded in an arbitration, and no one said anything about that. The Korean courts didn't consider that as a ground for refusing enforcement. So it's a bit gray, but I think for arbitration, I wouldn't say it's disallowed. I would say it's okay, but with the caveat that it's unsettled at the moment.
Right. Saman, what do you see are the issues or trends emerging in India around third-party funding? Right, because you said it's a gray area. It's not per se, it's not legislated anywhere. So what is it that you see?
So I think there are some obvious issues because it's not sort of regulated in India and everything is at its very nascent stage. There are some obvious issues that one can think of. I think to start with is conflict of interest. Does the arbitrator have a close pre-existing relationship with the funder in question? And if there is one, then that could raise questions on impartiality and independence. It's not necessarily an item which figures in the conflict schedule to the Act, but then Section 12 of the Arbitration Act is quite broad, and the arbitrator is required to disclose any fact which could give rise to a doubt on his independence and his non-partisan attitude. So conflict is something that I can think of straight away. The other is also confidentiality, because pursuant to the amendment to the Arbitration Act, arbitration proceedings are absolutely confidential, barring disclosure under applicable law, perhaps. But of course, for to get third party to fund your litigation, there will be some disclosure at some level on what is the nature of the case and perhaps the pleadings and so on and so forth. So how do you tackle with issues of confidentiality? That's the second aspect that I can think of. The third is also, I think, to some extent, costs. As a firm, we are doing a matter where the costs that were awarded, they were very, very steep, because a huge part of the cost actually constituted the cost of litigation funding, and that's something that we were representing the award debtor, and we weren't prepared to pay that kind of cost. And we said it is extortionate. So I think the net issue really over here is lack of a regulatory framework, and I think that's something that should be looked at immediately. And similar to England, where there are rules to govern how litigation funding, third-party litigation funding would work. What are the contours within which they work? How do you prevent them from not taking over the litigation? How do you prevent them from not taking over settlement discussions? I think those are the kind of things that really need a lot of work on, and hopefully that's something that that should happen in the coming times.
Right. And Tejas, how is... Sorry, James. Yeah.
No, go ahead, Ravi.
No, go ahead, please.
I'm just wondering whether what you're saying is going to be assisted by what's happening in Singapore recently, with the change of the third-party funding rules there, and given that many Indian parties agreed to arbitrate in Singapore, is this going to have a knock-on effect and encourage legislative development in India, but also in Korea, where again many Korean parties agreed to arbitrate in Singapore? So will the dominoes start to fall in the rest of Asia?
I think so, James. I think Singapore is... Sorry, go ahead.
No, I was just saying that India has always looked to Singapore to sort of evolve its international arbitration landscape. So I wouldn't be surprised.
And a lot of discussion around third-party funding now does take into account what's happening in Singapore. So you're absolutely right that is going to have an effect, and we'll definitely be drawing, I believe, a lot of what we will eventually frame from Singapore.
Right. And Tejas, what are we seeing at the ICC around third-party funding?
So I think this is something which was done last year in 2021 when the ICC revised its rules, again, in recognition of the fact that there is third-party funding and there is a growing need for transparency and accountability. The rules were revised, and the rules now state that parties must disclose the involvement of third-party funders to the parties, the Secretariat, and the Tribunal. So now this is explicitly mentioned in the articles, Article 11.7 of the ICC rules, where the disclosure has to be made. And this is, of course, in line with the idea that this disclosure will allow arbitrators to identify any conflicts and disclose those well in advance.
Right. I think with that we've sort of covered what we wanted to discuss. Any closing comments, generally experiences in the cross-border arbitration space that you think we just want to quickly close with? Saman, Mino, James, Tejas.
I think from an Indian perspective, I can definitely say there's been a sea change when it comes to arbitration, how it is not just the conduct of arbitration proceedings, which is now a lot more professional. You have more and more institutions coming in. There's a lot of cross-border work. There's coordination between Indian counsel, foreign counsel. So I would say it's a more sophisticated way of conducting arbitration, and also a hugely positive change when it comes to enforcement of awards. And as I said, I've not seen a major foreign award getting set aside in the past 5-6 years, and now it's really an uphill task to have a foreign award set aside. So I think it's all good, and it's all happening at a pace which is quite good. It's a change not only at the legislative level, but also practically in terms of how parties look at arbitration, in terms of how councils deal with arbitration. It's a lot more efficient and a lot less time consuming than it used to be.
Ravitej, if I may, Saman, and I'm so encouraged to hear about all the developments in India and Korea, particularly India, given really has received some bad press over the years. And Saman and Ravitej, what you've explained to us today is great, because it gives us great confidence that when we are entering into arbitration agreements with Indian parties, we can have confidence in the process, because they too have confidence in the process. The other thing that I'd mention is I think this event has been fantastic, bringing Korea and India together. I mean, this is really what international arbitration is about, exchanging ideas between jurisdictions like the ones we work in. So I'm just really grateful to be invited and to hear what you've all had to say today. So thank you.
Yes, thank you so much. I would echo that. So thank you so much for the invitation to Peter and Kim, to Khetan, Ravitej, and all my fellow panelists. I think if I were to just give my closing comments, I would say that arbitration is something that is the future, and that is something that we see continue to rise. There are so many institutions like the ICC that continue to benefit from arbitrations arising out of Korea, India. India is constantly ranked as a top 10 parties in ICC arbitrations over the last 5-6 years since I've been working at the ICC. And I think this trend will continue, this trend will grow. So I think there's just so much to do in this sector, on this corridor, and in India.
Yeah, I would like to thank Khetan and all the speakers too. I'm going to make a closing remark by opening a whole new topic, actually, which is outside enforcement of an award. Experienced a case where a Korean company and an Indian company had a dispute, and before the award came out, asset tracing and relevant Indian court measures were pretty effective to really get the client a satisfactory outcome, which I think is a topic for another webinar, but just wanted to put my experience on the table in lieu of a closing remark.
Thanks everyone. And you're right, and that becomes relevant also because in a foreign seated arbitration, where someone said that now under the Indian Act you can seek interim protections in India, because the seat is somewhere else, you sort of have the freedom to pick the court in India, and that's where asset tracing becomes relevant, because you then go to the court where the maximum assets are. But again, as you said, that's for another time. Thank you everyone for joining us. I hope we've tried to sort of, I mean, of course, we've tried to scratch the surface, which is, To go into each of them would be one webinar in itself, separate webinar for each of them. But yeah, thank you everyone for joining. If there are any questions, you can always reach out to us. You can write, you can email us, drop it on LinkedIn or wherever it is, and we'd be happy to sort of get back to you with our answers. Thank you so much, and have a pleasant evening and afternoon wherever you are.
Thanks so much. Thank you.
Bye.
Bye.